The scent system in Poland is an electronic mechanism for supervising the transport of selected categories of goods moving within Polish territory or passing through it in transit. Regulations do not cover every shipment. They apply only to transports of goods classified as sensitive. The scent obligations extend not only to Polish carriers, but also to foreign transport operators carrying goods into, out of, or across Poland. It is also important to distinguish the scent system from the RMPD system. RMPD is the Register of International Road Transport. It mainly applies to entities from outside the European Union, as well as to EU entities that carry out transport operations outside the European Union. These two systems are governed by different legal acts. More details on this topic can be found in articles published on our website. In this video, we focus on scent rather than on RMPD. The scent system and scent notifications are handled on the Polish Tax Administration's platform, PUESC. The monitoring system covers the transport of so-called sensitive goods identified by specific CN codes. In particular, monitoring applies to the transport of fuels, oils, gas, alcohol, lubricants, tobacco products, medicinal products, and certain types of waste, and as of March 2026, also clothing and footwear. It should be noted that the list of goods subject to the scent system is subject to change. The list of goods subject to monitoring changes over time. The list of goods covered by scent is also published in an abbreviated form on the PUESC website. It is important to always use the most up-to-date list, which should be marked with a date. However, as the tax administration itself notes, the compiled list does not constitute a source of law. It is for information purposes only. Therefore, in case of doubt, the provisions of the Act and the regulations are decisive. The film presents the course of proceedings concerning a confirmed scent violation for which a financial penalty may be imposed, identified during a roadside inspection or a check of the scent registration records.
At the very outset, it should be noted that the scent system is very demanding. Therefore, every effort should be made to avoid violations. If violations occur, the decision to initiate the appeal procedure must be carefully considered in order to avoid exposure to high costs.
If, during a roadside inspection, the inspectors identify violations, they will be described in the inspection report. The report should be signed by the inspectors and the driver. The driver has the right to submit comments or objections to the report, including objections regarding the procedure or the way in which the inspection was conducted. One copy of the inspection report is given to the driver. If a violation is identified for which the driver may be fined, the driver may be punished with a fine ranging from 5,000 Polish zlotys to 7,500 Polish zlotys. If the company or the driver does not agree with the identified violations, they may submit comments to the report. In such a situation, the driver may also refuse to accept the fine. In the case of foreign carriers, if the inspectors identify mistakes in scent declaration, they will collect a deposit in an amount corresponding to the anticipated financial penalty. Payment of the deposit is a condition for releasing the vehicle and goods for further travel. If the deposit is not paid, the vehicle together with the goods will be directed to or removed to a place indicated by the officers. The deposit is collected either in cash against receipt or in a cashless form if the collecting officer has the appropriate device to authorize the transaction. If the carrier is having their registered office in Poland, the penalty is payable after the completion of administrative proceedings. No deposit is collected from them. Financial penalties apply not only to transports inspected during road checks, but also to transports registered in the scent system, where irregularities are identified during a registry review. A repeated error in many notifications can result in numerous proceedings and very high penalties. It is not unusual for a carrier to face, for example, 50 proceedings, each imposing a 10,000 zlotys penalty, leading to a total of 500,000 zlotys. In cases of repeated failure to appear for inspection, there may be, for example, 40 proceedings, each imposing a 20,000 zlotys penalty, which may result in total penalties of 800,000 zlotys. Notices initiating proceedings are often delivered many months or even years after the irregularities occur. This makes it more difficult to identify and correct errors and leads to repeated violations by unaware companies. If a violation is identified during the inspection or a check of the scent registration records, the head of the Customs and Tax Office initiates ex officio proceedings to impose a financial penalty. The head of the Customs and Tax Office may also, prior to initiating the proceedings, request the party to provide explanations if there are doubts as to whether the violation was actually committed. In such a case, the proceedings are not yet initiated, and the authority awaits the party's explanations. If, in the assessment of the head of the Customs and Tax Office, a violation has been committed, the authority issues a notice of initiation of proceedings for the imposition of a financial penalty. After receiving the notice, The entrepreneur has the right to present their position, submit explanations, and file motions. The company may present or attach evidence in support of its position. Before issuing a decision, the head of the Customs and Tax Office should grant the party a period of at least 7 days to comment on the collected evidence. The statement should be submitted in writing. Failure to submit explanations within the time limit set by the authority does not result in the loss of the right to submit them later. They may be submitted until the conclusion of proceedings before the authority of second instance. After the expiry of the time limit for submitting explanations, the head of the Customs and Tax Office issues a decision. If the violations are confirmed, the head of the Customs and Tax Office imposes a financial penalty on the entrepreneur. If the head of the Customs and Tax Office finds that no violation occurred, the proceedings are discontinued. If a violation occurred but an important interest of the party or the public interest justifies refraining from imposing a penalty, the head of the Customs and Tax Office issues a decision waiving the imposition of a financial penalty. The possibility to waive the penalty is very important. It allows the authority not to impose a penalty despite finding a violation. The decision is served on the party together with instructions. These instructions should include information on the right to lodge an appeal when the decision becomes enforceable, and to which bank account the imposed penalty should be paid. An entrepreneur has the right to appeal against the decision of the head of the Customs and Tax Office. The appeal is filed with the competent director of the Tax Administration Chamber through the head of the Customs and Tax Office who issued the decision. The appeal must be filed within 14 days of receipt of the decision. Failure to meet the deadline deprives the company of the possibility to appeal against the decision imposing the financial penalty. The appeal should indicate the contested decision, i.e., the authority that issued it, the decision number, and its date. The allegations and their justification should be indicated, as well as a request to change or repeal the decision. The appeal must be signed. After the party files an appeal, the head of the Customs and Tax Office forwards the appeal together with the case files and a response to the appeal to the Director of the Tax Administration Chamber. In the course of the appeal proceedings, the party may submit explanations and present evidence. The appellate authority not only examines the allegations raised in the appeal, but in effect re-examines the entire case. After examining the appeal, the Director of the Tax Administration Chamber issues a decision in which they either uphold the contested decision of the head of the Customs and Tax Office or repeal it and decide on the merits of the case or discontinue the proceedings. The Director of the Tax Administration Chamber may also repeal the decision of the head and refer the case back for reconsideration. Proceedings before the head of the Customs and Tax Office and the Director of the Tax Administration Chamber are not subject to any court or stamp costs. Any fee relates solely to legal representation and depends on the terms of the agreement concluded with the attorney. After the conclusion of proceedings before the authorities, the decision becomes final, and if a penalty has been imposed, the company must pay it. Filing a complaint does not suspend the obligation to pay the penalty. Its payment may be suspended by the court upon the party's request included in the complaint. If the appellate authority does not uphold the appeal, the party is entitled to file a complaint with the Voivodeship Administrative Court. The complaint must be filed within 30 days from the date of service of the decision of the Director of the Tax Administration Chamber. The complaint should indicate the contested decision, the authority that issued it, the decision number, and its date. It should also include the allegations and their justification, as well as a request to repeal the contested decision. The complaint must be signed. The complaint is subject to a court fee, the amount of which depends on the amount of the imposed penalty. In the course of court administrative proceedings, the party, as a rule, may not present new evidence except for documentary evidence, provided that presenting such evidence before the authorities was not possible. Taking documentary evidence before the Voivodeship Administrative Court is an absolute exception. Therefore, all evidence should be presented at the stage of proceedings before the authorities. The Administrative Court reviews the legality of the decisions issued by the authorities, and the proceedings before it are formalized. Witnesses are not examined before the Administrative Court. After examining the complaint, the Voivodeship Administrative Court issues a judgment in which it dismisses the complaint or repeals the contested decision in whole or in part. The Administrative Court may also declare the contested decision null and void. If the court upholds the complaint, it prepares the written justification of the judgment ex officio and serves it on the party. If the Voivodeship Administrative Court does not uphold the complaint and dismisses it, the written justification of the judgment is prepared only upon the party's request. Such a request must be submitted in writing within 7 days from the date of announcement of the judgment. It should be noted that the time limit for submitting a request for justification runs from the date of announcement of the judgment, regardless of whether the party was present. The request for justification is subject to a fixed fee of 100 zlotys. Submitting a request for justification is a prerequisite for challenging the judgment by the company. Filing a complaint with the court may also involve the costs of a sworn translation of an extract from the commercial register. This applies to foreign companies, for example, limited liability companies. Unfortunately, the cost of such a translation may be high because it must be prepared by a sworn translator. It cannot be a machine translation. A cassation complaint to the Supreme Administrative Court may be filed against a judgment issued by the Voivodeship Administrative Court. It must be filed within 30 days from the date of service of a copy of the judgment together with the written justification. Failure to meet the deadline deprives the party of the possibility to challenge the judgment. Mandatory legal representation applies in such cases, which means that the cassation complaint must be prepared and filed by an advocate or legal counsel. The cassation complaint is subject to a court fee, the amount of which depends on the amount of the imposed penalty and equals half of the court fee payable for the complaint, but not less than 100 zlotys. In the course of proceedings before the Supreme Administrative Court, the party may not present new evidence. The proceedings are formalized. A party that did not file a cassation complaint is entitled to submit a response to the cassation complaint. After conducting the proceedings, usually after the first hearing, the Supreme Administrative Court issues a judgment in which it either dismisses the cassation complaint or repeals the judgment of the Voivodeship Administrative Court. The Supreme Administrative Court dismisses the cassation complaint if it does not accept the arguments of the party who filed it. If the cassation complaint is found to be justified and the judgment of the Voivodeship Administrative Court is repealed, the Supreme Administrative Court may also repeal the decisions of the authorities and even discontinue the proceedings concerning the imposition of the penalty. In summary, proceedings concerning a confirmed scent violation may involve several stages, beginning with a roadside inspection or a review of scent registration records, followed by administrative proceedings before the competent tax and customs authorities, and potentially judicial review before the administrative courts, and subsequently the Supreme Administrative Court. Each stage is subject to specific deadlines and formal requirements, and in some cases, professional legal representation is required. In the case of penalties imposed for violations of the scent regulations, each case is examined separately. This means that if several penalties are imposed on an entrepreneur, separate appeals must be filed in each case, and if pursued further, separate complaints must be submitted to the administrative courts. Administrative proceedings before the tax and customs authorities are generally free of charge. However, once the case is brought before an administrative court, court fees arise, as well as potential costs associated with legal representation. At each judicial stage, separate court fees apply, and they are charged individually for each case. If the company is unsuccessful before the administrative court, it may also be required to reimburse the authorities' costs of legal representation, which increases the overall costs of the proceedings. Conversely, if the company succeeds, these costs are refundable. For this reason, the decision to pursue judicial review should be carefully considered, taking into account potential risks, expected expenses, and the benefits of challenging the administrative decision. The decision to initiate the appeal procedure must be carefully considered in order to avoid exposure to high costs. If your company needs advice, clarification, or assistance in scent matters, we invite you to contact our transport law firm. You can also make use of our courses on how to operate the scent system. A link with our contact details can be found below the video.